On January 28, 2026, the world of intellectual property changed forever. For years, the name Lee Rothschild has been a shadow over the tech industry, a man who has filed over 1,200 patent lawsuits against everyone from Apple to small businesses. Most companies just pay him to go away. It's easier and it's usually cheaper. But he made one fatal mistake. He tried to squeeze Valve. If you've been following this channel, you know the drama has been insane. We've seen lawyers caught using AI to fake legal citations and then having to issue apologies. But now the games are over. A federal judge has issued a pair of devastating rulings that sided with Valve and functionally dismantled Rothschild's entire defense. The judge has officially ruled that Rothschild breached his contract, and in just a few weeks, Valve is taking this all the way to a jury trial to seek millions in damages. Valve isn't just winning, they are going to be setting a precedent that could end this patent troll for good. To understand why these new documents are so explosive, we have to look at the contract that started the war. Back in 2016, Valve and Rothschild entered into a global settlement and license agreement, or the GSLA. This was supposed to be kind of like a peace treaty. Valve paid Rothschild a valuable consideration, essentially a giant pile of cash, in exchange for a perpetual, irrevocable, royalty-free, fully paid-up worldwide license to Rothschild's patent portfolio. The agreement was pretty simple. Rothschild gets paid, and in return he promises not to sue licensee, Valve, or its affiliates for the actual or alleged infringement ever again. So for 6 years there was silence, but then in 2022, Rothschild's companies started sending marketing messages to Valve's legal team, essentially saying, hey, we have some new inventory of patents, want to buy a new license. Valve, knowing that they already had a perpetual license, ignored the emails. So Rothschild did what he always does, he sued them. Specifically, his company Display Technologies filed a lawsuit in September 2022 alleging Valve infringed on a patent that was already covered by the 2016 deal. When Valve's counsel pointed this out and emailed the Rothschild lawyers a copy of their own 2016 contract, they didn't just apologize, they actually doubled down until they were forced to dismiss the case. And that leads us to the explosive rulings the judge just handed down. In the recent ruling, Judge Jamal Whitehead finally addressed this. Rothschild's legal team tried to argue that because they dismissed the 2022 case promptly, it wasn't a real breach. But the judge wasn't having it. He wrote, the court finds as a matter of law that Rothschild and DT breached the GSLA by suing Valve on September 27, 2022, and that prompt dismissal of the lawsuit did not cure the breach. This is the partial part of the victory for Valve. For the 2022 conduct, Valve has already won. Rothschild is now a contract breaker in the eyes of the law. The only thing for a jury to decide on this point is how much money Rothschild owes Valve for the trouble he caused. In June 2023, Rothschild's lawyers sent another letter to Valve threatening to sue them over the 221 patent. This was after Valve had already warned them about the 2016 contract in the 2022 case. But Rothschild's excuse this time was that he claimed it was just a genuine mistake. His team argued that because Rothschild manages so many patents, they simply forgot the 221 patent was on the list of things they weren't allowed to sue Valve over. But here's the catch that makes the upcoming trial so important. The judge ruled that he could not grant summary judgment on this 2023 conduct, seeing as under Texas law, if a breach is based on a genuine mistake, it might not count as breaching the contract. So the judge stated that whether this was a lawful act or a genuine mistake is a genuine dispute of material fact. Now, this is where things change quite a bit. Rothschild's team tried to get the judge to throw out Valve's claims under the Washington Patent Troll Protection Act. They argued that only the Attorney General can sue under this act, not a private company like Valve. Valve. They wanted to keep this a simple private contract dispute. But in a recent document, Judge Whitehead just dropped the hammer. He ruled that Valve does have the right to sue under this act because patent trolling is a matter of vital public interest. He stated, "The court declines to adopt an interpretation that would leave injured parties without recourse while simultaneously declaring their injuries to be matters of vital public concern." By keeping the PTPA claim alive, the judge is allowing Valve to argue that Rothschild's business model is an unfair or deceptive act in trade or commerce. This opens the door for treble damages, meaning the jury could triple whatever amount of money they think Rothschild owes Valve. Valve is looking to make it financially devastating to ever target them again. And that leads us to one of the most satisfying parts of this case. Most patent trolls use a shell game strategy. They create dozens of tiny LLCs with no assets, and if an LLC loses a case, it just goes bankrupt and the troll walks away with their personal wealth untouched. They aren't just suing the companies like Display Technologies or Patent Asset Management. They are suing Lee Rothschild personally. They are arguing that these companies are just alter egos for Rothschild himself. If Valve succeeds in the upcoming trial, Lee Rothschild could be held personally responsible. Valve isn't just targeting Rothschild, they are actually going after his lawyers too, Samuel Meyler and Meyler Legal PLLC. This is where the case gets truly personal, as in many legal battles the lawyers are shielded by what's called litigation privilege, but Valve is pushing back against that shield. Valve's in-house counsel warned Meyler as early as December 2022 that his behavior indicated a failure to do a Rule 11 inquiry, which is lawyer talk for you didn't do your homework before filing this lawsuit. Meyler responded in January 2023, claiming he had carefully reviewed the GSLA. Yet just 6 months later, Meyler sent a letter threatening to sue over the 221 patent, a patent he just claimed to have carefully reviewed. When challenged on this, his defense was that he did not realize the 221 patent was listed in the GSLA, and that he had relied on his client to track licenses. Valve is arguing that the Meyler defendants were active participants in a bad faith scheme to extract settlements through unfair or deceptive acts. Valve is sending a terrifying message to the patent troll industry. In a recent document, the judge allowed these claims to move forward. This means the Meyler defendants are officially headed to trial and could be on the hook for damages alongside Rothschild himself. So where does that leave us? The trial is actually set to begin in just a few weeks in Seattle, and because of these summary judgment rulings, the trial will be about the damages and how much Rothschild owes Valve. The 2023 mistake, was it an actual genuine mistake, or was he just trying to extract money? And personal liability for Rothschild. This overall is a massive win for Valve, but it's an even bigger one for the tech community. Valve chose to fight this time, spending millions of dollars and going through fake AI citations, but now they are weeks away from potentially dealing a death blow to one of the most known patent trolls in US history. If you want to stay updated on all Valve news, make sure you subscribe.